I'm going to apologise in advance. My wife got me the box set of The Simpsons for Christmas. So, as we'll see, we're all Simpsons episodes today. So yeah, we'll be going through 5 duty things that we got over the line in the past year and a bit. We'll start off with probably one of the bigger ones, which I think is quite good. So in this one, we've got a transaction where Millhouse has bought all of the units in the radioactive man unit trust from Bart. It's paid $10 million for it. The assets that the radioactive man unit trust owned was a head company, which then owned 3 separate companies all involved in a business, but for all intents and purposes, one overall business. And on top of that, they owned 35 Industry Way, real property located in Queensland. And in terms of costs, to buy the land and build that factory on it cost $10 million. There was a notional market value between the parties, or what they thought the actual land was worth, which was about $30 million. But as it transpired, Millhouse only paid 10. So Millhouse came up to us and said, "Tom, what do I have to pay in duty?" So the initial thinking was, somewhere around 10 or 30. Millhouse goes, but Tom, I'm paying 10 million and I'm getting all of this here plus the land. I don't want to pay 10 million on all of that. So one of the ways for stamp duty purposes is that you can determine a value for the land by what's called the subtractive method. It was a subtractive or top-down approach, if you've heard of it. What we did was we took the purchase price, 10 million, added back the liabilities of those companies for 32. Then we started picking off the value of what all of the non-land assets were, which ultimately, cars, non-fixed plant and equipment, stock in trade, all of that, debtors. Those non-land assets fit us at 38 million. And then that gave us the residuary, which was 4 million, and we submitted on that basis. Now, in Queensland, the subtractive approach has been adopted by OSR for some time, about 30 odd years. So, notwithstanding the book said the building cost $10 million to build, that it would have some notional value if they were to sell it outside of this transaction of 30 million. They said, no, look, we'll accept it at 4 million, gave us a duty result of 210. But the alternatives were $500,000 or a little over $500,000 in duty, or if we went off and got independent valuer to look at it and we had to submit on that basis, about 1.7. So useful in these sorts of transactions. It's really only used for landholder duty calculations. If the land was sort of up there, might have been a bit of a different story, but we were able to get it across the line in this scenario. The only thing I would say is that this whole approach is currently before the High Court, annoyingly. Took them 30 years to get there, and it actually came out of WA. And the reason it came out of WA is because the WA Duties Act is the bloke that wrote it took the Queensland Act and said, oh yeah, let's use that. So that's why it's there, and they got special leave on 28th of February, I think. So watch this space. Shouldn't really affect Queensland though. Next one is a declaration of trust over units. Another good one for being able to convey units to new people without having to pay some stamp duty. And this is one that we actually put together. We tested it out with a couple of I think Steve and Kieran in the end, where I had I had a brand new trust for Kieran, a brand new trust for Steve, and they were each beneficiaries on primary. Had a lot of fun with that submission to the state taxes. I think the duty in the end for all of that to test this out was $1.50 on each limit of the transaction. So in this one, again, same sort of deal. We've got Bart, who is the default beneficiary and trustee of the Bart Simpson Family Trust. Bart Simpson Family Trust owns all of the units in the Radioactive Man Unit Trust, and the Radioactive Man Unit Trust owns some real property in Queensland. And what Bart does is he declares that instead of him being instead of his trust owning the units in the unit trust for this trust, he declares that he instead holds them on trust for the Van Houten Family Trust. And we've got it over the line with OSR that is not a dutiable transaction. Usually if you're going to start if you had done a direct transfer from Bart Simpson Family Trust over to the Van Houten Family Trust, you would pay stamp duty on the basis that a trust acquisition. But in this situation, because there is a declaration of trust and units in a unit trust are not dutiable property, there's no dutiable transaction. In addition, it's not a trust acquisition, because if you make sure that your Radioactive Man Unit Trust has an appropriate clause in it called a CPT custodian clause, which just says if you're a unit holder, you've got no rights to the underlying land here, you've just got your rights to units. There's nothing which you can assess duty for when you do this declaration. So there's no trust acquisition and no trust surrender, which means yes, you can get those units from Bart Simpson Family Trust to the Van Houten Family Trust without paying duty. The one aspect of it all is we are recommending you maintain the same trustee for both arrangements, so it works in inter-family relationships and close related party type transactions, just because of this maintaining the same trustee. We look at the next one, and Kieran's going to deal with this probably in a little bit more detail because it's got some interesting superannuation benefits. This is section 118, family trusts. Effectively what the section says is if you have a trust acquisition or a trust surrender in a family trust, you don't pay stamp duty. The problem is traditionally most discretionary trusts in Australia have a very, very broad objects clause. So, it is the primary beneficiary, sons, daughters, wives, spouses, nephews, nieces, companies, trusts, just about as anyone in Australia. And what 118 says is that the trust needs to be maintained primarily or principally for the benefit of the family. And OSR has traditionally taken a very narrow view of that particular clause, by which they say, look, if you've got a very broad beneficiaries clause, that trust is not for the benefit of that particular family because it's not narrow enough. Of late, however, we've been seeing a relaxing of that attitude, and they're currently saying if Homer says, I don't want to be a default beneficiary anymore, but gets then put in as a default beneficiary without 118, that would trigger a stamp duty implication, again, based on the value of that land. But they're now saying, oh, look, depending on even with that broader beneficiaries clause, we'll let it slide. So I believe Kieran's got a couple of things in the OSR testing that out at the moment, and we'll let you know how that gets on. Trust cloning, stamp duty win discussion or presentation wouldn't be finished without a trust cloning thing. But most people would have seen this before. It's what's called a 53(2). It's not necessarily an exemption, but it's just a quirk of the Queensland Act. What this provision actually allows is for you to go from, say, one trust to two trusts. In this example, we've got a nice property, passive asset, pretty soft, and a Mr. Plough snow ploughing business. Now, as you can imagine, a snow ploughing business in Queensland is not going to work very well for very long. There's probably a lot of risk in here. So what we can do is then we can declare a trust over a particular asset, so long as you do it properly and the trust interests match up between these two new trusts. You can have a separate trust with the property in it and all those old liabilities, and the snow ploughing business, which is about to hit the wall, can stay there. So that's always a useful one to keep in the back pocket. And the fifth and final one is probably more of a planning point than a win, but things to be aware of is that in New South Wales, marketable securities duty has been abolished, so you can deal with shares, you can deal with units in a unit trust without paying any stamp duty. That's to the extent that there's no underlying land assets in New South Wales with a value greater than $2 million, because then you get into landholder problems. But a good planning strategy, and here's the scenario. We've got Homer here. He's a sole unit holder in the Rural Route 9 unit trust. He's a primary producer growing tobacco. Again, sorry, Simpsons, I can't help myself. So properties in New South Wales, and what Homer can do, whether this here is the Rural Route 9 unit trust, Rural Route 9 Proprietary Limited, however you want to structure it. He can transfer shares or units in that trust or company through to Laramie Cigarette Co. And so long as the value of that property is under $2 million, he can do that without paying stamp duty. The benefit obviously is if he's saving $50,000, $60,000 in stamp duty, he can ask for an additional purchase price for that. So that's it. Thank you very much.